Live.
It's like we're Hollywood.
That's right.
Straighten my robe. That's right. Get ourselves all in the center of the picture. Good morning.
Hear
Welcome.
ye.
Go right ahead. Court cry would be appropriate.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format because of the ongoing pandemic. The panel this morning is Justice Blake, Justice Kinder, and I'm Gabrielle Wolohojian. Although we're conducting court in this format, all the ordinary rules apply just as though we were live in our ordinary courtroom, and that includes the fact that each side gets 15 minutes to argue with no rebuttal. With that, I'm going to call the case of Commonwealth versus Antonio Frasier, number 2019 P0065. And we are ready whenever you are, Attorney Shaw.
Presiding Justice Wolohojian, and may it please the court, my name is Robert Shaw. I'm privileged to appear today on behalf of Antonio Frasier. My intention this morning is to begin with the DNA issues and then address the closing argument and hopefully have an opportunity to touch upon the GSR and the severance issues as well. Now, with respect to the DNA, the first question is, did error occur? The second question concerns prejudice. And in my briefs, I've addressed testimony about the DNA of the victim and the co-defendant in order to show the full range and progression of errors. But my focus today is squarely on the DNA testimony linking Mr. Frasier to the glove. That testimony was
Is that
error.
Preserved?
I would say that it likely is not preserved, Your Honor, because defense counsel went up with an objection and then inexplicably withdrew his objection, which I'll address. But that testimony was error because the government took a minor profile for which 1 and 1 was the only statistic that could be generated, and then artificially separated out that single location linked to that statistic, conceded that it was probative of nothing, but then asserted that the other below threshold locations without a statistic show that Frasier was included. He's a potential contributor. He can't be excluded. Assertions that were all in violation of the SJC's jurisprudence. Now, the Commonwealth has 3 lines of response to this that I'd like to address. First, they say, well, we gave a statistic that satisfies the rule, and that enabled the jury to evaluate probative value. And the answer to that is that no, it did not allow the jury to evaluate probative value because the jury was told explicitly that that statistic applied only to the one location, yet the analyst was relying on other locations in order to implicate Mr. Frasier. Second, the Commonwealth says that there was a challenge to the investigation under Bowden that justified this testimony. There was no challenge in this case that had anything to do with the DNA in terms of the investigation. And
but you would agree, Mr. Shaw, that the defense centered around things such as that your client was misidentified, they didn't pursue other suspects, they didn't pursue the individual, I think his name was De Los Santos, who purportedly found the gun. And so why isn't their argument that it was a fair response to the lack or the inadequate police investigation fair?
Well, for a few reasons. First, the challenges that took place concerned, there's no policy concerning the show-ups. This individual found the gun, and then, looking at cell records, which really weren't relevant given the fact that it's obvious that they were in the area. These things don't have to do with forensic evidence. And according to Wordsworth, as the SJC said, if you're going to have a response, it needs to be relevant to the challenges that the defense makes. And these don't concern forensic evidence.
Why it's not relevant to the defense of misidentity. If the defense is, it wasn't me, and the DNA is being offered to tie your client or link your client to the scene. Help me with that.
Well, I think that you can see, for example, in the Cabot case, where the SJC said, well, there was a challenge to the investigation, but it concerned eyewitness identification. It didn't concern DNA. This is very similar to that, I would suggest. But let's assume, Your Honor, that just for purposes of argument, let's assume that you could rationalize that this has some relationship. The next problem is that doesn't make inadmissible evidence admissible. That doesn't allow the government to then go into DNA evidence that is below threshold, that shouldn't come in anyway, that you can't even get a statistic for. It's simply inadmissible, and it would not have allowed this evidence to come in substantively the way it did. So Bowden certainly can't allow this type of testimony to come in.
Even if we were to agree that there were error, could you please address prejudice?
Yes, Your Honor.
Or I should say substantial risk of a miscarriage of justice.
Right, and we suggest that this clearly created a substantial risk of miscarriage of justice. Here we go ahead.
Yeah, so I'll tell you frankly, what's bothering me here is that given the remainder of the evidence and given the defense, it's hard for me to see how, even if this DNA evidence was erroneously admitted, that there could be a substantial risk of a miscarriage of justice. And the piece of evidence that gives me real pause is the back of the cell phone and the place and circumstances in which it was found. And where that combined with where the remainder of the cell phone was, which was in the defendant's pocket.
Yes, I'm not actually sure that during the trial they directly linked those, but I understand you can draw the inference. Right. Well, I think the fact, Your Honor, is that here we have an identification case that resulted in a deadlock at day 3. We have 5 days of deliberation. The identification evidence in this case is replete with contradiction and conflict, and that conflict is set forth in my brief, very thoroughly addresses everything from clothing to hair to the show-ups, and it even involves Detective Padalero, who says that he saw 2 people coming from Mill Street and then running back that direction, whereas Laura, who was with the victim, says the assailants came from Newberry Street, which is on the exact opposite side, and then that afterwards they fled to a car that was on Essex Street and drove off. And so the problem here is that there is a lot of conflicting evidence in this case. And as the SJC has said in the cases I cited in my reply brief, when there is this amount of conflict, particularly in an identification case, it is for a jury to make that ultimate decision. That this court respectfully should not be stepping in to say, well, we think, and sort of trying to weigh the credibility and go through that analysis when there is this much contradiction and conflict.
I'd like to ask you a question. You began your answer by pointing to the fact that the jury reported deadlock after 3 days. And
yes.
You tied that to the question of identification. But is there anything in the record that indicates that that was the issue over which the jury were deadlocked?
Well, I think that the primary issue in this case is identification. And at day 3.
But that wasn't my question. My question was whether there was anything in the record to indicate the issue over which the jury were deadlocked.
Well, I'm not sure in the normal course of things that a jury would report that kind of detail.
Well, sometimes they write notes.
Well, I think here simply what they reported is that we're deadlocked.
Right. So you don't, I mean, you know, we have verdicts that are lesser on lesser charges than were the indictments that so we don't know what it is that the jury was deadlocked over.
That's true. I think that's going to be true in almost all cases, Your Honor.
Right. So that's why I just wanted to understand your answer, because you put that in the mix with the evidence on identification.
Well, I think that
I didn't understand that.
Well, I just think that I think it's clear from looking at the record and the gist of this case that this is essentially an identification case, and they're coming back as deadlocked, and they're going on to deliberate for 5 days. So this is not a case where there is overwhelming evidence. And I think that's the central point, that this factor of a deadlock and 5 days of deliberation can and should be taken into account, as the cases indicate. Now, we also have prejudice that arises in two forms from defense counsel's ineffective assistance of counsel. He goes to the sidebar. He knows he needs to object. He says he doesn't know what the analyst is going to say, and yet then he inexplicably withdraws his objection. He doesn't even bother to find out what the analyst will say, and then he notes to the court that I want to defend myself later. And then during cross-examination, the only thing that he is able to do is to address the fact that 1 and 1 isn't probative of anything. He doesn't understand the other issues. He goes on the record later with the judge. He explains his struggle, and again, he demonstrates on the record that he was completely ignorant of the issues. And so that is another source of prejudice. I think that was clearly ineffective assistance of counsel.
There was no motion for new trial raised on this ground, was there?
No, there wasn't, Your Honor. But when you look at what he did on the record and what he said on the record, I mean, he's explaining his reasoning on the record. It shows that he doesn't understand the issues clearly. And it's very apparent on the record. In addition to the fact that, what happened here with this DNA evidence is just wrong on so many counts. I mean, it's just completely violative of the SJC's rules. Now, with respect to the closing argument, the prosecutor in this case suggested to the jury that they should view Mr. Frasier as a hired hitman who traveled to Lawrence with a preconceived plan to kill because he had some undisclosed, because there was some undisclosed third person who lost money, became angry, and then made the victim essentially an enemy and hired somebody to kill him, essentially telling the jury that, this is the lens through which you can view and understand this evidence. And there is no evidence in this case of a problem or a dispute involving the victim and gaming, no evidence of anger or a plan or an agreement to kill for money. All of this.
Mr. Shaw, would you agree that as a general proposition, if defense counsel as part of argument is asking the jury, where is the evidence of motive, then certainly the prosecutor is entitled to respond, correct?
The prosecutor is entitled to respond, Your Honor, and as indicated in the cases in my reply brief, must stay within the evidence in a reasonable and fair way. In addition, in this case, it is defense counsel who was responding to the prosecutor's opening statement, where she is suggesting in the opening statement without basis that he went to Lawrence with a preconceived plan to kill. And so the fair response was the one that defense counsel gave. And that doesn't permit the prosecutor to then fight fire with fire and go outside of the evidence. And I think it's really important to distinguish here an inference that is drawn as part of a small step in a progression of reasoning that fits within a larger foundation of supportive evidence, and something that occurs here where we have a prosecutor who's framing the entire case with a theory in closing argument that this is a hired hitman case, and labeling Antonio Frasier in that manner without any evidence to support it, none. And I think that was clearly error. With respect to the GSR issue, I think the core issue in this case is that under the Johnston case, the fact that a test was negative for want of sufficient number of particles is admissible, and perhaps even the number of particles is admissible.
Can you address the preservation question on the GSR?
Yes. Well, I think that as indicated in my reply brief, with a lot of cases cited, defense counsel was late, but it was accepted as timely by the judge, and the judge had the opportunity to correct it, and he refused to do so. And that's preserved. Under basic law, that's preserved. Now, the problem here is that Johnston does not say that you can treat a negative result as positive. And this has become a real problem in our jurisprudence. I mean, I am seeing this in homicide cases over and over and over again. We have the prosecutor who made an obvious effort to depict the scientific lab's negative result as negative in name only. In other words, that's just what we have to call it. It's a negative result that doesn't have anything to do with what this actually means or how it is used. And in this case, the prosecutor elicited and emphasized the lesser number of particles. It's negative in name only, essentially, and emphasizing that really, this is gunshot residue and it couldn't be anything else. And what that does is it renders the lab scientific testing standard meaningless. Now, as you indicate, Your Honor, there was an objection accepted as timely, but the judge's response was to say, well, the testimony was thoroughly explored. Well, it wasn't thoroughly explored because the exploration only addressed the fact that according to the lab standard, it's negative.
But didn't the prosecutor clean that up at transcript 6 around page 90? When the prosecutor asked, when you say or testify you found, I believe you said a total of 2 particles on Antonio Frazier's hands, and the question goes on, and the the expert responded 2 separate particles containing all 3 components. Didn't that clarify that?
I don't believe so, Your Honor. And I think it's important here because you sort of have to look at all of the testimony. The gist of the testimony was to emphasize those lesser number of particles, but to go on and essentially say that this couldn't have been anything but gunshot residue, and to use it in order to implicate Mr. Frasier. And you'll note that at the end, the judge says, quote, the ultimate conclusion of the expert was that they did not confirm gunshot residue, so the 2 particles is not enough, close quote. That's his explanation. But the fact is that it's incorrect. The record shows that the prosecutor was attempting to confirm this as gunshot residue, albeit with a lesser number of particles, and emphasize that it was inculpatory.
I think we're going to have to leave it there. Your time is up. Let me see if there are any other questions. No. All right. Thank you. Attorney Leary.
Good morning. May it please the court. Catherine Leary for the Commonwealth. I will first start with the DNA issue. In this case, I'm going to start first with the non-exclusion and the fact that it was appropriately used in this case. It's clear from Matai that you need to have a statistic, and the purpose of that when you have non-exclusion evidence is so the jury knows how to weigh it, so they're not misled into thinking it's as close of a match as matched testimony is in the quadrillions or those big numbers. And here, that's what happened when there was non-exclusion evidence coming in. It was very clear that there was only one statistic able to be done at one of the alleles, and that the crime lab does use below threshold DNA alleles when they're looking at exclusion or non-exclusion. And I would suggest that that is absolutely appropriate and proper testimony based on, I'm sorry, Your Honor, did you have a question?
Yes, I do. Thank you. If it's 1-to-1, exactly what does that mean? That it's the chance of anybody matching is the same as anybody else matching? Is that what 1-to-1 means?
So yeah, Your Honor, my understanding is at that specific allele, as the DNA analyst explained, it just happens to be common in a lot of the population. And so for the statistics she was able to generate, as she explained, you look at all of the information you have when you do inclusion, exclusion, and then you look at all the alleles for which you can do a statistic at. At that specific allele, it could be 1-to-1. So it essentially could be anybody. It could be you, it could be me, it could be the defendant.
Great.
And the reason why it's probative in this case, this is not inconclusive evidence, because if it was inconclusive, the details of such would not be allowed in under the case law. But this is not inconclusive evidence. And so, but the reason why this 1-to-1 is relevant in this case is because of the Bowden defense. The integrity of the police investigation was challenged very broadly. Under Wadsworth, it just says it needs to be within the scope. Basically, how big of a scope the challenge is, the Commonwealth can respond with a big scope. And here,
How
it would
does,
not.
how does a one-to-one result meet the standard threshold for admissibility of any kind of evidence, that it be more probative than prejudicial? Because I don't, in my mind, a Bowden, the idea that there's a Bowden defense being mounted, you would just probably be able to say in response to that, we conducted DNA testing.
Well,
And
Your Honor,
nothing more. In other words, you could respond with the details of your investigation, but where the details of the investigation don't actually lead to any kind of scientific information that's probative of anything, because this is not probative. It matches one-to-one, which is why I asked you to explain what one-to-one meant. If it means it could be anybody, how is that probative of an issue in the trial?
well, Your Honor, I guess my understanding of this is that here, just to put it in a broad frame and zoning in the probative value, is the point of this evidence is, right, there's a Bowden defense, these are the tests we concluded, and these are the results of the tests. And I think it's absolutely fair under the case law to be able to say, these are the results. And so I understand your point of saying one-to-one, it doesn't really necessarily prove anything, but I think the fact that this is just the results, it's non-exclusion evidence, I don't think it would be, I think it would be misleading the jury to say it's inconclusive and just to say it was inconclusive and that's it. But
now, why isn't it misleading to introduce it at all when it shows nothing?
it's not misleading because the jury, it was made very much aware of the import or lack thereof, I guess, of this evidence. And so it's not misleading because they're not left with a false misimpression, which is the concern under Matai in that line of cases. And also, I would like to point out the fact that while there was an objection and it was withdrawn, I think it was, we don't know on this record exactly completely what the thinking of Attorney Karp was, because there isn't a motion for new trial, but it behooved him to be able to destroy this evidence and to show it wasn't very strong, because quite frankly, this was a very strong circumstantial case. And so it behooved him to make this more of a science case in the fact of, yeah, let me challenge this evidence and show it really means nothing. The Commonwealth case isn't that strong. And so in that respect, also, if we're going to be looking at this under a substantial risk of miscarriage of justice, one of the prongs that you look at is, was this tactical at all? And onto this record, I don't think you can, it wasn't. And so that's also, it could be relevant for that reason, also for him to be able to attack that. So I think in this case, as this case was being tried, obviously the DNA evidence was developing. I think here, the whole point of it is saying, these are the tests that were done, and these are the results of the tests. And the jury was able to weigh that evidence. And so there was no risk of misleading or confusing them.
Is there any inference that can be drawn from the jury verdict of a lesser included offense?
I don't think so. I mean, juries do stuff all the time and they nullify it all the time, and we don't know why they would do what they do. But I would also point to the fact that I don't think the jury was, and we don't really read into jury deliberations, but here they did have jury questions that they sent back. And one of the questions was about whether or not you can convict for first degree murder if you, I believe that if you didn't pull the trigger. So to me, that suggests they struggled with the co-defendant because there's testimony that he had looked surprised and he was not the alleged gunman by the Commonwealth. So if we can read anything into the record, I think it suggests that they were not conflicted over evidence about the defendant per se. But again, we don't read into jury deliberations. And as the court has noted, this is a very strong case. That cell phone panel, it was a fair inference and was linked for the jury that was the defendant's back of his cell phone that had come out of two pieces of his pants pockets when he was found around the perimeter, out of breath, in a t-shirt on November 29th with shrubbery in his clothing. And also his very inconsistent statement saying that Ben had driven him to Lawrence, and then his Volvo was found in the flight path, his car keys taken off of him with the co-defendant's personal papers found in that car. and yes, there was eyewitness identification, but that was just added to the strong circumstantial case. This was not a case that for the Commonwealth that rested on that eyewitness ID. And I would suggest a very strong.
What does the record show exactly with respect to the back of the cell phone and its proximity to the glove?
So the record, I believe, try to find the volume site for you. The evidence about the cell phone was that it was found in the bushes near a sweatshirt and a jacket, and the glove was found in the pocket of the sweatshirt. So the cell phone was found in that area. It doesn't say it's found on the sweatshirt, but it's found in conjunction with those in the bushes behind Museum Square, which is where the Officer Pelladero saw the defendant run towards, which is consistent with where he turned up by the courthouse.
So the word near is about as descriptive as the record gets about exactly where it was.
Correct. Near, in the same location of the bushes, near the sweatshirts. And the jury, that's a very strong inference that it's the back of a cell phone. His cell phone was in a battery in the front part, but also close proximity, out of breath. There was a lot for the jury to find here that it's pretty strong evidence.
Can you address the prosecutor's closing and sort of this hired paid hitman?
Yes, Your Honor.
Is that a fair inference?
I think it's absolutely a fair inference, but I would first like to address the prosecutor did not bring up motive in her opening statement. She said the defendant and co-defendant came with a purpose. That is speaking to their intent. That's not saying the why. And so it was not started by the prosecutor. It was started by the defense attorney in his closing argument, where he said, where's the motive? And so the Commonwealth, based on the evidence, has every right to rebut that and say, you want a motive? Well, this is a fair inference from the evidence. There's a lot of money that comes through this gaming room. And if if the victim's in charge of collecting that evidence, then that can make somebody mad. And of course, the strongest motive evidence would be directly linked to the specific defendant, but this is an explanation about why somebody might want the victim dead. And so based on that evidence, as Judge Wilkins found, that's a fair inference from the evidence and a fair response to defense attorney's closing argument.
What about the gunshot residue?
Sure. So I would first note that the Commonwealth's position is that this was an untimely objection and that there was a motion to strike that was considered, but I don't know if that necessarily is enough for the judge to say he accepted it. But even if we want to go under a prejudicial error standard of review, which the Commonwealth does not concede based on the late nature of that objection, here, the prosecutor did absolutely everything appropriately. And this case is on all fours with Johnston. She basically said, this is how we get a positive result. These are the three component particles of gunshot residue. And this is how we get a positive result. Here, there was no positive result, but there were two particles on his hands. So, but that's still negative. And it was made very clear for the jury, and the jury could make whatever inference they want out of that. And that's what Johnston says, is that prosecutor just put the information for the jury, and then they can decide, hey, that's a negative, so we're not going to consider it, or these are unique components and maybe that means something. And that's absolutely proper. And I would also note the prosecutor just elicited this testimony on direct and redirect examination, but she didn't argue it in closing to say there's a positive result. She never even touched it in her closing. So I think the way this evidence came out was absolutely proper and within the bounds described by Johnston.
What is the inference that you think a jury could properly draw from two particles?
I think the jury could properly draw the fact that his hands were in proximity of a firearm that had been
Is
shot.
that within a layperson's ability to draw that inference?
I think it is when they hear about that gunshot residue is this unique unique particles. It has these three unique component particles. There are only two other things in the entire world have it. And so while they know that you need 3 of those for a positive result. Well, there's 2 there. And I believe they also heard testimony that gunshot residue can get wiped off and all this other stuff. So they can make a link saying it was on his hands. He might've wiped his hands. So that's why there's 2. I mean, I think that's definitely within a jury to be able to figure out and put 2 and 2 together, because they were given the tools about what's GSR, what's not GSR, what's a positive, what's a negative result, and they can put it together. I definitely think that's within a jury's capacity.
And the expert was not asked to draw a conclusion from this evidence.
Absolutely not. In fact, the prosecutor clarified, as you noted, that on page, I think volume 6, page 90, that she clarified this was absolutely, it's a negative result, and we cannot make a conclusion or know anything about whether the defendant's hands were in the proximity of or touched a firearm that had been fired, nor would you be able to, even if it had been a positive result. And that was made clear on the record.
What have our cases said about why it's necessary to have expert testimony regarding gunshot residue?
I think it's because it's based on a scientific test. I'm not entirely sure I understand your question. I think it would be the nature, right, of how does gunshot residue get formed? How does it get on somebody's hands, possibly, or clothing? How do you test for that? That is all stuff outside of a lay person's knowledge. But once that's admitted and all that foundational evidence is in, a jury can make whatever inference they want out of it. So I'm not sure if I fully answered your question. I would assume that's more basically my understanding of the law and expert witnesses and why you need them and how it will relate to a gunshot residue expert. But I think that would be correct. Unless the court has any other questions, I'm happy to rest on my brief.
Let me see. No, thank you both. It's a very interesting case.
Thank you.
And we are going live and on the record.
Good morning and welcome to this sitting of the Massachusetts Appeals Court, which is being conducted in this format due to the ongoing pandemic. Nonetheless, all the ordinary rules of oral argument in our courtroom apply, including that each side gets 15 minutes to argue with no rebuttal. With that, I'll call the case of Commonwealth versus MARLEY WHONDA, case number 2020 P0316. I'd like to remind everybody that the case is partially impounded so that we should not use names. And Mr. Attorney Vizone, we're ready whenever you are.
Thank you, Your Honor. Please, the court, Joseph Vizone. I represent MARLEY WHONDA, the defendant. I have a number of issues for the court's consideration today. The first one is whether or not the evidence of kidnapping was sufficient, specifically with regard to the intent. As the court knows from reading the transcripts, the young woman was able to leave the apartment when he was at work. She could come and go as she pleased. She was almost always in possession of a cell phone, so she could have called. And eventually, at the end of the day, so to speak, she did call someone and notified them of where she was, and she was picked up. So again, the question is, what's in the defendant's mind? Did he specifically intend to restrain this woman? And I would suggest that she didn't. Now, I know there is case law, Your Honors, with regard to how threats and fear in the mind of the defendant plays out in such a charge as kidnapping. I get that. I would note that on cross-examination, when she was asked about, why didn't you just, when you were in the cab, she one time she took a cab ride. She said that was on cross-examination. The defense attorney says that was a good opportunity for you to tell the cab driver of your plight and to seek refuge. And she says, well, I didn't think anybody would care. She didn't say I was too frightened to tell the cab driver for, not frightened of the cab driver, obviously, but frightened of the defendant in terms of what he would do. So with that.
Mr. Vizone,
yes,
couldn't the jury draw a reasonable inference that if he threatened to kill her, and told her that she was being watched when she was outside of his residence, that it would have been reasonable for her to infer the necessary element of fear?
Well, again, Judge, I kind of wonder how fearful this individual was. I mean, we have a situation here where the woman one night on South Main Street in Worcester, which is not the best area of Worcester, walks up to a car with two unidentified men, engages them in conversation, and gets in a car with two men. So she wasn't fearful of doing that. I mean, it goes again to this whole notion of, was she kidnapped? Was she trafficked? Or she was just an individual who had a very severe drug addiction, tragically, and needed to engage in this kind of behavior in order to satisfy her drug habit. So,
Well, I understand.
Sorry.
Sorry to interrupt, but I understand that certainly is one view of the evidence. But of course, at this point on this issue, we're considering the evidence in the light most favorable to the prosecution.
Right.
And what inferences the jury might draw from that.
Correct. I realize that, Lattimore is a little bit of a difficult road to hoe here, as, the case that it came from, Jackson versus Virginia, always had a little bit of difficulty with that. But I get Your Honor's point. But again, the focus here, I believe, has to be in what's in the defendant's mind. Did he specifically intend to restrain this person? I don't know if you could prove his intent to restrain by trying to guess, so to speak, what his words and phrases would have, the effect they would have on the young woman's psyche in terms of, well,
Attorney,
Yes,
so can I add to Judge Kinder's list of facts there and
yes,
add in the evidence that the defendant told the victim she belonged to him and that he assaulted her quite significantly on the one occasion when she tried to escape. So if you add those two to the mix, again, in the light most favorable, why is that insufficient?
well, again, it's, conceitedly, Your Honor, it's not the strongest argument that one could make. Again, Lattimore and all those cases suggest that, you don't make a judge does not make credibility issues when deciding a motion for a judgment of acquittal. He just decides, or they would decide, taking the evidence in the light most favorable to the government. So you just assume that the jury is going to believe everything that the prosecution says, and they would discount everything that the defense says. And against that, Judge, it makes it for not the strongest argument. But again, I think
that
Yes,
do you think that if a defendant manipulates another person's drug dependency, that could be part of the mix in this calculation?
in terms of his specific intent to restrain this individual?
Exactly.
I suppose that's a good argument, Your Honor. I mean, yes, to some degree, that he knows she's a drug addict, and he knows that if she doesn't get her drugs, she will be in a bad way, so to speak, because of the dependency.
And if he's a supplier, for example.
I'm sorry, Your Honor?
And if he's the supplier, for example.
The evidence seems to suggest that she was getting her drugs from him. Yes, that's correct.
And I take it that this argument goes only to the kidnapping charge.
Yes, Judge.
Correct?
Yeah,
Okay.
Judge, yes. So if I could move on to my next argument, if I could, Your Honor. The second argument was there was a pretrial motion filed to dismiss the indictments for failure of the prosecutor to provide the petit jury, the grand jury, I'm sorry, the grand jury with exculpatory evidence, specifically from one Audra Blaze, who had testified at the arraignment, at the bail hearing, dangerousness hearing, that she did not see anything that was consistent with him raping this woman or other or assaultive behavior. Now, again, I know those two items don't go to trafficking, but again, the overall flavor of this case, if you will, is the credibility of the complaining witness.
But
And
that's exactly what your brother says, right, in response in his brief, that this was not a question of exoneration. This was a question of witness credibility, and therefore it wasn't exculpatory. So can you respond to that?
well, I think if you look at the memorandum of decision of Judge Gavin Reardon, when he decided the motion, I think he said that Ms. Blaze's testimony, could be characterized, if you will, as exculpatory. The issue in his mind was, it wasn't exculpatory enough so that there would be any prejudice visited upon the defendant's
Well,
case.
he said, although some of of her dangerous hearing testimony was exculpatory in nature, it did not exonerate the defendant from the crimes he was alleged to have committed. That's at record 40. So
Right.
What is the standard?
Well, it's not, I agree, it's not complete exoneration, but the question is, as I said in the brief, is that if there is a possibility, a reasonable possibility that the outcome of the indictment would be different. In other words, the jury would not have indicted him had they known about this information. And it's also, I believe that the case law suggests that the prosecutor has some obligation to present this type of exculpatory evidence, exculpatory impeachment evidence, because the whole thing revolves around exculpatory impeachment evidence. And so in that regard, Justice Blake, I think that the prosecutor in this case, the grand jury prosecutor, had an obligation to at least put this on the table for the grand jury.
What's your strongest case on the question of credibility versus exoneration and the exculpatory evidence being presented to the grand jury? What's the closest factual case that you have?
Well, let me check my, again, technology here. If I could just bear with me a second, please.
Certainly.
I have two computers in front of me and I'm trying to. Well, I guess the cases that I cited in the brief, Judge Noble and McGahee and Odell, they suggest, and I put it in quote, as long as the evidence before the grand jury was sufficient to warrant a conclusion of probable cause, and that the proceedings likely would have been impaired. So.
Okay.
So.
Do we have Ms. Blaze's testimony somewhere in the record?
We do, Judge. As I stated, she testified at the dangerousness hearing.
But is that in our record, the appellate record? I couldn't find it.
Well, it should be, Judge, because the pretrial motion, which was authored by another attorney, referenced that.
But the judge in his decision referenced having listened to a CD of her testimony. Do we have that CD?
I believe the Superior Court would have it, Judge.
All right, so we don't have it in our appellate record.
If Your Honor is telling me that it's not there, then I'm not gonna
Okay,
disagree with Your Honor, but I believe
I couldn't see it. I couldn't see it or a transcript of it. So we need that.
Yes, Your Honor, and I will. If Your Honor is asking me to take steps to.
Yes, that would, if you could work together, the two of you.
Yeah, I will certainly work.
The prosecutor's great.
Prosecutor.
Thank you, and get that to us as soon as you can.
Absolutely, Judge, absolutely. Great. Okay, Judge, I'd like to go to what I believe is my strongest argument here is this videotaped statement that the defendant made with the police, an interview. I don't want to call it a confession. But it was objected. Two things were objected to at trial. One was that the entire video was not an admission of guilt. It was just the opposite. And specifically with regard to the statement that he made, I'm not into that trafficking stuff. There was argument at sidebar about whether that I'm not into that trafficking stuff should be redacted. There was a number of things redacted in this video, but there was a question about that one, Judge. And at the end of the day, Judge Mulqueen, decided that it should remain in. And I just felt that, again,
I don't think we have this video either. Is that correct?
well, it went into evidence, Judge.
Well, those things don't come to us automatically, so we need a copy of that video as well. If so, maybe both of those things could
Yes,
be
Judge, I
sent to us.
apologize to the court on that.
That's okay.
I know it's in the record because it was
Mhm.
much ado about it. But in any event, he says to the police officers, I'm not into that trafficking stuff, because they get on a question about his cell phone. And he says, she's always sending me text messages, and I tell her, don't send me these text messages. I'm not your pimp. I don't care what you did last night with on one of your quote unquote dates.
Because we're short on time, could I just interrupt you?
Yes.
This section of your brief relies heavily on Commonwealth versus non, and your brother indicates that non was overruled by WOMAC, and I want to know what your view is of that.
Well,
Is non still good law?
No, it was overruled by WOMAC. But at the same point is, in terms of, I make the next argument about it being propensity evidence, Your Honor. And I believe, I also, Judge, just while I'm thinking of it, there was a reply brief that I also have. I just hope the
Yes,
court is
we
aware.
have it.
Yeah, okay. Again, that was very prejudicial. Just the, I'm not into that trafficking stuff, I found to be extremely prejudicial. I don't believe that the judge was correct in leaving that in. It does, if you compare the probative value of it versus prejudicial, it's highly prejudicial, because the jury is going to wonder why this guy is on trial for trafficking, and why would he use this, I'm not in this trafficking. Most,
Well, is it, your brother says it's an admission and it's also a statement of a party opponent. Can you respond to that?
I don't think it's a statement of a party opponent, Judge, because a party opponent, self-serving statements, my understanding, are not a party admission. It has to be a statement against one's interest. That's what gives it the indicia of reliability. It makes it an exception. Again, when you say I'm not into that trafficking stuff, that's not an admission. You say, I don't do that stuff. Okay. And that's the point. The point is, he makes a statement, and it's in the transcripts, where the court is aware that he did have a prior trafficking charge that was dismissed, had nothing to do with this case. Okay. So that's where he got that trafficking. The word trafficking is kind of a term of art. Most people, if you're not a lawyer or a judge, you might not, have that as part of your lexicon. And yet this guy is out talking about trafficking. And I see my time has expired, Your Honor. So
Let me see if there are any further questions. No, thank you very much. We have your argument, we have your briefs. Thank you. Attorney Bowden.
Good morning, Your Honors. Nathaniel Bodwin for the Commonwealth. In terms of the first issue raised about the sufficiency of the evidence of the kidnapping conviction, I would say that in the light most favorable to the Commonwealth here, the evidence was more than sufficient to convict the defendant. You had the defendant, again, as came out during the previous argument, that he told her pretty soon after meeting her that she now belonged to him, told her that he would kill her if she told anyone about what was occurring. Threatened her that if she ever tried to escape, she would send people out to find her. Kidnapping simply is the forcible confinement of another person. And confinement is broadly interpreted as any restraint of a person's movement. And although that crime doesn't require any physical force, you actually had physical force here, as was discussed in the previous.
The kidnapping charge, was it based on the whole period of time, like several weeks?
Yes, yes. It was a period about two and a half to 3 weeks in November.
So 2.5 to 3 weeks. And during that period, she's physically unrestrained for large chunks of time, right?
Well, I would to that point, Your Honor, I would say when the victim testified that first, when she was at home during the day, when she wasn't out being forced into prostitution, she was staying in a bedroom. The defendant instructed her to place an air conditioner in front of the door and a piece of wood in front of the door so that no one could enter. She was instructed to seek permission whenever she wanted to eat and whenever she wanted to use the bathroom. And there was testimony that there was on one occasion, in order to show his power over the victim, the defendant would not allow her to use the bathroom.
Sure, I'm not talking about the times when she's in the apartment. I'm
Okay,
talking about the periods when she's outside of the apartment.
so those periods, she was told by the defendant that when she was out on the street, she was being watched. On cross-examination, she was asked, well, did you see anyone watching you? And her response was, well, I suppose if they were any good, I wouldn't see them. So she was under the impression that she was being followed and watched during those times. And the defendant, I believe, at least on one circumstance that was testified to, called cabs for the victim to go to those areas. There were other times. So I do believe that the fact that she thinks she's being watched when she's out on the street, in addition to the times where she's confined in that bedroom and following the defendant's instructions, I think both of those scenarios, when she's out in the street and in that room, there was sufficient evidence that she was forcibly confined.
What is the closest case on these facts where the kidnapping charge rests on a period of time during which the victim is outside of the physical control of the defendant for chunks of it?
I did not find a specific case that had these set of facts. I did rely on Bibby and Lent. I believe in those situations, it involved, I believe, a hotel room or a motel room. So I do say I did not find a similar case with this set of facts. And obviously there were a series of other issues, Your Honor. I can move on to I believe Attorney Vazone said, we can go into the video that was introduced there, unless Your Honors have further questions on the kidnapping. What the argument was at trial in terms of the defendant's statement, it was argued that this was an unequivocal denial of guilt, and that's just not the case here. When the defendant brought up the trafficking, that the statement, "I'm not into trafficking," that wasn't a direct question from the detective. Were you trafficking this young woman? What that was the defendant trying to explain away a series of inculpatory evidence that was presented to him. That there were a series of that the detective was told that there were text messages on his phone that if one were to read them, and he agreed that if you were to read them, you would get the impression he was her pimp. And so what that statement was him trying to say, well, I don't know why she's sending me these texts. I'm telling her to please stop. I don't want people to interpret me as being your pimp. So that was not an unequivocal denial of guilt. And again, in terms of what is a statement of a party opponent, that I think that there's a broad definition there, and it's an exception to the hearsay rule. So I think for those reasons, the fact that this was considered to be an admission, as well as a statement of a party opponent, the judge properly allowed those statements into evidence.
Are you saying that if it's if this were an exculpatory statement, just accept for the moment that this were purely exculpatory or purely a denial of guilt statement, unequivocal denial of guilt to the police, would you agree that the fact that it may be considered a statement of a party opponent would not override the rule that it's inadmissible?
Yes, Your Honor, that would make sense. If he was asked, did you traffic this woman? He said no, that would not.
You're not going to be able to get that in as an exception to the hearsay rule.
Correct, Your Honor. I would agree.
So what relationship does your hearsay argument have here to the defendant's argument?
Well, that was brought up in terms of the first argument about the statement in its entirety. So I brought that up in terms of the entire statement, which the
The
defendant.
entire recorded statement.
That is correct.
Okay, so not with respect to this particular exchange.
Yes, Your Honor.
Okay, that clears things up for me. Thank you.
And I'm sorry, I just wanted to briefly just go back to the kidnapping because I think it's an important point. The defendant in his brief, and I believe here today, said that the victim was always carrying a cell phone with her when she was out on the street. That is not accurate. The victim testified that once after being held by the defendant for 2 weeks, then she was allowed to take a cell phone with her on 2 or 3 occasions. The purpose of that being to inform the defendant of her activities, to provide license plate numbers of those individuals she was engaged in dates with. And those were the phones that were given to her were associates of the defendant.
I actually wanted to ask you another kidnapping question.
Sure.
In our human trafficking cases, we have the discussion of the continuing offense doctrine and the unit of prosecution as to why somebody can be convicted of human trafficking for events that take place over a period of time in order to protect a discrete victim. Does that same doctrine apply to kidnapping?
I'm not aware that it does, Your Honor.
Okay.
Not aware that it does.
Could the defendant have been indicted for each and every day of that 2.5 to 3 week period?
For human trafficking.
For kidnapping.
For kidnapping. I do think the way the evidence was presented here, there could have been additional indictments for kidnapping. Again, as I stated before, you could look at her confinement within the apartment. You could also look at her confinement out in the streets due to her fear, due to the impression that she was being watched. So I think there is some potential for that here, Your Honor.
And I apologize, I don't have it at my fingertips, but did the indictment for kidnapping say on diverse dates?
I believe, I believe all the indictments have the dates November 1st through November 18th of 2018.
And then was there a bill of particulars?
I don't necessarily recall if there was.
I'll look for it. Thank you.
Okay. And if there are no further questions, Your Honor, Your Honors, I'd be glad to rest on my brief.
No, I have a question actually about the limitation on cross-examination.
Sure. With the defendant's mother, the final claim.
Yeah,
Okay. Well,
it's the victim's mother and
Yeah.
her employment. You know, why? So the defendant argues that that it was an error to sustain the Commonwealth's objection to his exploring this on cross-examination of the victim. And can you please, why is it that the fact that the mother is employed by law enforcement and therefore potentially capable of summoning aid quickly and efficiently to a call from the daughter, why wouldn't that be a permissible line of cross-examination for the defendant?
so I believe the discussion at sidebar, when that objection was made, sort of the defense counsel alluded to what you were saying, Your Honor, that, what the defendant stated in his brief, I believe, was had the victim placed a call to her mother, I believe it was something along the lines of help would have been coming in short order. The mother's employment with the state police, and again, didn't come out exactly what she did for the state police, was not relevant, especially when you consider the fact that you had the mother's testimony that who I believe the testimony was she had sort of mother's intuition that something was not going right here when she was no longer receiving her calls, that she pretty swiftly started going to the city of Worcester. She's not from the area, looking in area hotels, hospitals, filing a missing persons report, engaging with a Worcester detective who was showing the victim's picture to individuals who were homeless in the community.
I don't understand the line to really be anything particular to the mother. The defense pursued the line of, you didn't call 911, you didn't summon a passing car, you didn't, whatever, the whole list of things that the victim didn't do, all of which appear to me at least to be permissible lines of cross-examination. Why doesn't the same question geared towards the mother? You didn't call your mother for help. You didn't call. Why wasn't that permissible? Why was the line drawn there?
I believe the judge also didn't find it relevant after the prosecutor argued that from the victim's testimony, particularly when she was talking about who she had sent Facebook messages to, there was some testimony that she purposely did not send a message to her immediate family members. So the defendant would not see someone with her last name and therefore put those individuals in danger. She only contacted people or friends who had different last names for her out of concern for her safety. So I think that played into the judge's decision here that information was not relevant, that her mother's employment with the state police wasn't relevant.
Let me come at it a slightly different way. Would you agree that someone who has a family connection with the state police is more likely to be in a position to contact the state police easily than someone who does not have that family connection?
Your Honor, I would say to that, I think anyone has the ability to, based on the evidence here, I don't think that was relevant because you had the mother acting very quickly to engage police. No, it was not the state police. It was the police, the law enforcement of the city in which she believed her daughter to be missing.
Relevance is a pretty low bar. Would you agree with that?
Lower bar than other objections, yes,
And
Your Honor.
it's not really what the mother's doing. It's the question is, what was the victim's frame of mind as to why she did or did not seek help from any source?
And I guess I would say, Your Honor, that let's say the question was let's say the defense counsel was allowed to ask that question, it would have had little effect because I believe the victim would have again repeated that she wasn't calling her family to protect them, that she wasn't involving her mother in any device, which was, this device was Scott McFarland's computer, at least when it came to the Facebook messages. She wasn't going to put any information about her family on a device owned by an associate of the defendant. So I think that's what we could have anticipated the victim saying. And if there are now no further questions, I can certainly rest on my brief. I do want to make one note for the record, Your Honors, that I believe sometime in the past 4 weeks, this defendant's sentence has been reduced by the appellate division of the Superior Court from 10 to 15 years to 9 to 10 years. And I just wanted you to note that that's not in the record before you.
All right. I don't know that that's, I'll just say a couple things. Would the two of you please try to get the missing parts of the record to us as soon as possible? That's the CD of the witness's statement and the recording of the defendant's statement to police. And if you want to update us just together, send a joint letter telling us what the defendant's revised sentence is now.
I'd be glad to do that, Your Honor.
Thank you both. And as soon as you can would be helpful. If it's possible to get us those things in a week, that would be ideal.
Thank you, Your Honors.
Thank you both. It's an interesting case, and we've been helped by
Live and on the record.
Good morning. Welcome to this sitting of the Massachusetts Appeals Court. With me this morning are Justices Blake and Justice Kinder, and my name is Gabrielle Wolohojian. Although we are conducting argument in this format due to the ongoing pandemic, all the ordinary rules of argument apply, including that each side gets 15 minutes to argue with no rebuttal. With that, I'm going to call the case of Commonwealth versus Norman Franks, number 2019 P1120. And Attorney Yellen, we are ready whenever you are.
Your Honors, Charlie Yellen for the defendant Norman Franks. I hope to discuss 3 issues this morning, starting with sufficiency of the evidence. This case should be reversed because there's a fatal gap in the Commonwealth's evidence as to whether Jerry Elliott was in jail from June to September. The Commonwealth has a burden. It's a burden to provide sufficient evidence for guilt beyond a reasonable doubt. And we allocate the burden to the Commonwealth, not just for the protection of Norman Franks, for the protection of all of us. And so the Commonwealth should not be allowed to slide by on evidence as thin as it provided here.
Does it matter, Mr. Yellen, if he's in jail or not, if your client took the money and didn't use it for any purpose and just kept the money, didn't use it to bail him or any other reason, just kept it?
Well, if there was evidence that he kept the money, or that if he, as you said, used it for some other purpose, then that would be sufficient.
But does the sufficiency argument hinge on whether or not her husband was in jail?
I think in this case it does.
Why?
Well, I think that's the case that the Commonwealth was making.
Well, but the larceny by false pretenses was dismissed, right? So this
Right.
conviction is for larceny under. And is the fact that the gentleman was or wasn't in jail an element of that offense?
Well, no, I think it's the way the Commonwealth is trying to prove that he, permanently deprived the Audrey Elliott of her money.
What ordinarily do our cases say is required in order to satisfy the element of permanent deprivation? It doesn't need to be to the end of time, correct?
That's correct. It doesn't need to be to the end of time. I think if the Commonwealth had succeeded in providing sufficient evidence that Jerry was in jail for this period of time, it would have been sufficient. I think that would have done the trick. I just
But
don't.
why wouldn't 2 days do the trick? As long as the defendant takes the money, to put it colloquially, and doesn't use it for its intended purpose, why isn't that enough?
I think 2 days would not be enough, Your Honor. I think to deprive.
If he took the money, if the defendant took the money and that very afternoon, and I know these are not the facts of this case, and that very afternoon went and spent it on a new car, right? You would have permanent deprivation within hours.
Absolutely.
Right. So it doesn't really seem to depend on the a length of time that the victim's husband spends in jail.
Well, no, and the way you position that, you're right. And I think that's what Justice Blake may have been getting at too. If there is evidence that he used the money for some other purpose, of course, that would do the trick.
But here we don't have that. So I take it your argument is, in order to establish the element of permanent deprivation, you have to look to the amount of time that the victim's husband remained in jail.
That's correct. That's correct. There needs to be evidence that he was in jail for a certain length of time, and the Commonwealth is trying to prove their only evidence was Audrey Elliott's statement that he was in jail for these 3 months.
Now, if the defendant, let's just change the hypothetical a little bit. If the defendant says to the victim, if you wire me the money, I'm going to skedaddle right over to the jail and use it to get your husband out. And not only is there no skedaddling, but the defendant is, doesn't hear from him anymore. The husband's still in jail, and the defendant has gone radio silent. Why is that not enough to show that the defendant intended to permanently deprive the victim of the money?
Well, because we have nothing after the Facebook messages on the evening of the 9th.
Well, Mr. Yellen, I'm sorry to interrupt your answer, but on that very point, you do know that in June, or we know that in June from the record, he's in custody and bail is set in the amount of $1,000. We also know that the $820 is then sent. There's communication between the victim and the defendant. And 3 months later, approximately, the defendant is still in custody, still bail is $1,000, and he then gets out at that point. Is there any evidence to suggest that he was not in jail the entire time, which would be, I think, a reasonable inference?
It is potentially a reasonable inference based on what Audrey Elliott testified to. You can say it was a reasonable inference that he was in jail the entire time. What I suggest is that there's another inference that is equally plausible, or plausible enough, that points to innocence. If you consider the Commonwealth's evidence here, Your Honor, the Commonwealth's evidence include a very long Facebook message, the longest Facebook message from Audrey Elliott to Norman Franks about Jerry Elliott. We have to consider the Commonwealth's evidence here. Jerry Elliott, sadly, from his wife, we learn he's a very troubled person, and he's a danger to himself, to others, his family. He's bringing weapons into courtrooms. His rage cannot be contained. So there's another inference I think is plausible, that Jerry Elliott could have gotten out of jail well before Audrey bailed him out and then got back into jail. I don't think that's flamboyantly implausible, as the case is
Well,
in
let's assume, Mr. Yellen, that there are two conflicting inferences, and let's assume, just for purposes of this question, that they're equally plausible. Isn't that for the judge to decide, the fact finder?
Well, I think it would be, yes, but I think I'm saying we're saying on appeal here that there was a mistake there, that the case should be reversed based on that.
But we're viewing the evidence, of course, in the light most favorable to the prosecution, and that's one of the inferences we're talking about.
Yes, Your Honor, you have to view the evidence in the light most favorable. But I would say, my brother can suggest and you can select any light in the spectrum, and it's not going to obscure that gap in evidence that we have here. And I would ask you also, Your Honors, I would ask you to contrast the evidence provided with respect to how long Jerry's in jail with the evidence provided by the Commonwealth on the subject of whether the money was wired to Norman. Now, they met their burden there. They filled the gap. There's a continuous chain of evidence. You have the Western Union receipt. So I think the contrast of how they carried their burden in one area and didn't carry it in another area is significant. And I would also add this. There is, if the evidence existed to show that Jerry was in jail the entire time, as they proved with respect to wiring the money, how easy would it have been for the Commonwealth to admit that into evidence? At the risk of a sports metaphor, it seems like that was a layup, and one wonders how they missed it. So I think that that's important to keep in mind, Your Honor.
Can I ask you to move on to your argument with respect to identification or mistaken identification?
Yes, and I can do that very quickly, Your Honors, because I'm going to concede that issue. On preparing for oral argument, reviewing all of the papers in the case, including my brother's brief, I determined that's the right thing to do. So I would like to concede that and move on to my next issue.
Very well.
And that issue is the exculpatory evidence issue, which concerns the victim impact statement. And for that, Your Honors, we need to adhere to what the late Chief Justice Gantz wrote on September 8th, in what was certainly one of his last published decisions. I can give you the site. He provided emphatic guidance to the Commonwealth on its duties to disclose information. He wrote the duty applies to all information, and he underscored the word all information that tends to indicate the defendant may not be guilty, including information that could impeach the credibility of a key witness. Here,
Mr. Yellen, let me interrupt with a question and lurch forward just a little bit. This is a case where the issue was brought up at sentencing, and the judge took evidence on that very point and heard testimony from the victim and considered it and made certain findings, coming to the conclusion that there was nothing inconsistent about the victim impact statement, given the timing of that statement. So I'm hard pressed, given the judge's conclusion there, to determine why this was exculpatory in nature.
Well, Your Honors, the judge did conduct voir dire. She basically substituted, I think, the voir dire for the time-honored practice of cross-examination. It wasn't an adequate substitute. The judge can't be testing the liability of the witness. The defendant should be doing that. That's how we flesh out the truth. We do defer to a judge's assessment of credibility of a witness, but we don't imbue the judges with powers of clairvoyance.
Well, do you agree, Mr. Yellen, that the victim impact statement was given in July, approximately a month and a half after he was first incarcerated?
Yes.
All right. So doesn't that reflect the time he would have been incarcerated at that point when she said it was 35 days?
Well, you know, she says in the voir dire, at that quote, at that point when I wrote it, it was 35 days. Does that mean it was she wrote it on the 35th day that he was in jail? Well, okay, maybe. But then a few seconds later, she says she wrote it the day before it was dated. It's dated the 23rd. If she wrote it on the 22nd, that's the 46th day he's in jail. That's an 11-day difference. It's highly improbable. It makes no sense in a way. And then later she says, or a few seconds later, she says, quote, he wasn't released the entire time he was there. Well, that tells us nothing. What I want to know is, why did she write that he got out of jail at all? It just invites a practiced trial attorney to offer an effective, vigorous cross-examination. The judge in the hearing on November 13th, you have that transcript now, the judge was very clear. She pinned her decision on two points. And one point was much more important to the judge than the other. The first point she said is, well, I took a look at the victim impact statement. This was a victim impact statement. I took a look at the statute covering that, and it doesn't anticipate being disclosed in discovery. Well, that may be true. The statute may not, but it's the Constitution that demands that exculpatory evidence be turned over. But the biggest reason that the judge had for denying the motion, the judge said that there's the second part of the sentence in the victim impact statement. where she wrote that Jerry was in jail, quote, because his uncle had to steal the money. Well, that just repeats the testimony she offered at trial. It does nothing to aid us in our quest in learning why she wrote he was ultimately there for 35 days. It begs the involvement of cross-examination.
I think we have your argument. Let me see if there are any other questions. No. All right. Thank you very much. We'll hear now from Attorney Blatchford.
Thank you. May it please the court, Howard Blatchford, Assistant District Attorney for Middlesex on behalf of the Commonwealth. The evidence here was sufficient to prove beyond a reasonable doubt that the defendant was guilty of larceny. Looking at that evidence in the light most favorable to the Commonwealth and drawing all reasonable inferences, a rational trier of fact could easily determine that the defendant specifically intended to permanently deprive the victim of her property and infer, to the extent it's even necessary, that the husband, her husband, was still in jail when she paid the $1,000 in September. The key
It
facts
does seem, Mr. Blatchford, it seems that Mr. Yellen has a point that if in fact the defendant was, I'm sorry, the husband was in custody the entire time, that would have been an easy fact for the Commonwealth to prove. And yet there is an absence of proof between June and September about the status of the husband.
I'd respectfully disagree with that, Your Honor. The victim did testify that the husband was still in jail in September. Did she testify that he was there every single day in between? No, but that would be a reasonable inference, I would suggest, that the trier of fact could infer from the facts that were proven. In fact, to adopt or accept the defendant's position here, one would have to assume that the husband was released from his initial incarceration, that he was rearrested again for some unknown, unspecified offense, that he was taken to the very same jail out in Worcester County with bail set in the exact same amount. Otherwise, that theory falls apart. And I would suggest that those facts would fall into the category of what the case law refers to as being entirely speculative and flamboyantly implausible. It just is so impossible to imagine that those facts would exist that they should be disregarded completely. So that's basically the Commonwealth's argument on that point. With respect to the victim impact statement, I point out first, as the Commonwealth noted in its brief, that the issue is really not properly before the court. No notice of appeal was ever filed from the order denying that motion, the Rule 25B2 motion.
Well, there is an open motion pending, though, before us, a defendant's motion to apply notice of appeal to denial of motion for relief. That's an open motion.
It is indeed, Your Honor.
So hypothetically, if we were to allow that, would that alleviate your concern?
It wouldn't alleviate our concern because we believe the notice of appeal should have been filed from that. But we recognize that that motion has been filed, and we addressed the argument on the merits in the brief as well. Our position is, the Commonwealth's position is that the email from the victim of July 23rd is not exculpatory. It doesn't negate the guilt of the defendant, nor does it support his innocence. And simply put, I think the email is inartfully written as it may be. There's clearly a miscalculation of time in there by a few days at least. Is not in any way suggests that the defendant was not guilty of this crime. The victim testified that she wrote it around the day, at least, that is born on the email, July 23rd, and that the incarceration period at that point in time was, she said 35 days. It could have been as much as 46, but nonetheless, he was still incarcerated when she paid the bail, $1,000, the same amount as had always been at the Air District Court at the end of August or the beginning of September. Turning briefly to the last argument in the brief on the motion for new trial, there was no evidence before the court that the judge had actually received the defendant's Corey report before she rendered her verdict. The defense counsel in her affidavit in support of that motion doesn't identify the document as the quarterly report. She carefully phrases it as what she believed to be the quarterly report without describing what she saw in the court officer's hand. She doesn't say that she saw the judge read it. Obviously, she was in chambers and could not see that. And defense counsel only saw essentially the court officer take a document, a paper, into the judge's chambers. And when the judge came out, the judge handed a paper back to him. We don't know whether it was the same paper. We don't know what it was. So in that
But
circumstance,
didn't the judge at some point in that timeline ask about a triple I?
yes, she did. She said that she recognized that there was some out-of-state residence, but that can be explained by the victim's own testimony on direct examination when she testified that a photograph was taken of the defendant when he lived or was in Florida. So there was evidence before the court that the defendant had been out of state at some point in time.
But she's asking about a criminal record nonetheless.
Well, she said, I know that there's some out-of-state contact or out-of-state residence. I forget the exact word. So she didn't specifically ask. It was in the context of her search for information at sentencing post-verdict concerning the defendant's criminal record. But she wasn't really asking per se about a conviction that occurred out of state. She knew he was out of state.
Did she ask about the triple I before or after she issued her verdict?
It was at post-verdict during the sentencing phase.
Okay.
Of the hearing. So there was no evidence which could form the basis for an argument that defense counsel was in some manner not performing to the standards that she should have been, and was no prejudice to the defendant from that.
The judge
unless there are any further questions, go ahead.
Yes,
Your Honor.
the judge did make findings on that final point, correct? Regarding whether or not he saw, stating specifically that she did not see or consider any criminal history.
Yeah, she in her order denying the most recent motion for new trial, she specifically stated she did not review that criminal record, nor would she have if it had been brought into her chamber. She specifically denied the allegations that the defendant has made with respect to this issue. And she was the trial judge, the motion judge. I think that really shuts the door on that argument, Your Honor. And unless there are further questions, the Commonwealth would submit on its brief.
I don't see any, seeing none. Thank you both for your arguments. You've been both.
Are going live and on the record.
Good morning and welcome to this sitting of the Massachusetts Appeals Court, which we are conducting in this format due to the ongoing pandemic. Although we are conducting court in this fashion, all the ordinary rules of our courtroom apply, including that each side has 15 minutes to argue with no rebuttal. With that, I'll call the case of Michelle Holdings LLC versus Kim Johnston, case number 2019 P 1444, and Attorney Turk. We're ready whenever you are.
Thank you, Your Honors. May it please the court, my name is Jeffrey Turk and I appear today for the plaintiff appellant in this case. Your Honor, this was a basic landlord-tenant case in which the plaintiff brought a claim for unpaid rent and breach of contract and fraud, and the defendant claimed breach of conditions and security deposit violations. I'd like to start with the security deposit issue, Your Honor, to start. The issue here, Your Honor, is the tenant claimed that she did not get a receipt for her security deposit. The court excluded the admission of the receipt at issue in the case.
Attorney Turk, before you get into the substantive arguments, and I know you have many of them, I have, I guess, a general overriding question or concern, which is that, and I read your reply brief. I mean the appellee brief, to which there was no reply brief. I'm concerned that the brief perhaps misrepresents some of the record on some incredibly salient points. For example, on the security deposit issue, the jurors in their special verdict did not make a finding based on that. Instead, they made a finding for your client's failure to deposit the security deposit in a compliant account. And so I was wondering, when you got the appellee brief, why you didn't file a reply brief as to those allegations that you misrepresented the record.
Well, Your Honor, I guess what I would say is I think the problem is you don't have, the judge should not allow the salient document to be put into evidence or to even be marked into the record. So there's no way for the appeals court, which is clearly an error, to not be allowing even the document to be marked for identification,
I guess
which
my
she
question
fails
is
to do.
broader. My question is broader than that, though. You don't disagree that the jurors didn't make a finding on the question of the receipt, right?
Correct,
Your
Your
whole
Honor.
security deposit argument is premised on the failure to include the alleged receipt but the jury decision was based on the security deposit account. And I see those as different. And I see your argument as somewhat disingenuous because that's not what the jury found. And I guess I'm asking you to help me understand places where your brother suggests you strayed from the record.
Your Honor, here's what I would say. First of all, the problem is that the document at issue, which you don't have before you because the judge would not allow us to mark it for identification, had the account number on it. So the allegation that they didn't get to the issue because they didn't find that there was it was in the proper account is because the receipt that you don't have before you, and I can't show you because the judge improperly wouldn't even let me mark it for identification, had the account number on it. I don't know how to show you that, Your Honor, because again, I can't even put that before you because the judge clearly improperly did not allow me to mark it. I just want to also suggest to Your Honor that if you look at the transcript that counsel puts in, RA5 line 116, counsel agrees to the judge that it's irrelevant to the claim, whether it was in the proper account. He says to the judge when we're arguing about it that it's irrelevant to the claim, and he acknowledges that the issue is the lack of the receipt. That's his own words at the trial when we're arguing about this issue. So I think the problem is that the salient receipt that I can't show you has the account number on it and has all the information on it.
Well, then let me try this a different way then. In your second claim of error, you say it was error to exclude a complete copy of a document because it was partially already in evidence. But as I understand your brother's brief, what you were trying to put in was the neighbor's security deposit documentation. And as to this case, that would be irrelevant. So again, it was an area in the record where there were two vastly different sets of facts, and I'm trying to figure out what the facts are. And you don't respond to the allegation that, again, this was straying from the actual record.
And Your Honor, in relation to that assertion that what was the relevance of that document, the relevance is that, again, the whole factual issue was they were saying there was this receipt that had handwritten information on it, including the account information. Entering that other document into evidence would have shown that that was the practice of taking that receipt that was in evidence, Exhibit 7, and then adding into it the account number, which is the only way you could do it. When you were giving out that document, it was not, you could not have added the account number into it because at that point, when you're giving out that receipt, Exhibit 7, you don't have the account number yet because you have to enter it once you get the money. You don't even have the date you received it. So Exhibit 7 is the original document attached. The exhibit that we weren't allowed to even introduce would have had the account number, as is the attachment to the complaint, which they entered into evidence, which again would have shown that the process was to add that account number after you get the money, as is required by Chapter 186, Section 15B. So that was the error in admitting that other document, not only because, again, it's an incomplete document. You're allowing a certified record from the court to go in.
Right, to a verified complaint that had to do with an assault that occurred in your client's property. And that was the purpose for which it was offered, not to show that the other tenant had the proper security deposit paperwork.
No, Your Honor, but we would have used it to show that, whereas, again, the factual issue of them saying the receipt Exhibit 7 was not was the receipt that was given to her, not a subsequent security deposit receipt as required by the statute with the account number written in. That document, as a certified record of the court, would have come in to show that fact, that, again, you're required to handwrite in or write in the account number once you receive the deposit. You give a receipt when you receive it, then you have to, within 30 days, give the receipt with the account number actually written in once you've actually deposited it into that account. You obviously can't do that at that time.
But didn't your client actually create this problem by virtue of what occurred at the 30B6 deposition?
I would disagree with that strongly, Your Honor, because again, first of all, there was nothing in the record for the judge to decide that. You have no deposition transcript. You have nothing that shows that at the deposition of Mr. Karabulad, he testified that anything about this phantom receipt that's not marked as an exhibit. And in fact, Your Honor, he was asked as the 30B6 deponent, do you know about this receipt? He was shown Exhibit 7. He said, I don't. He was never shown the exhibit that we went to enter. Counsel had it. It was produced in discovery, but he was not asked at his deposition.
3 times, twice right in front of Judge Winnick in 15 and 16, and then in front of the trial judge in 18, about what had occurred at the deposition, what the substantive testimony was and was not, and that you would be precluded from introducing that based on what happened at the 30B6 designated deposition.
No, Your Honor. In fact, if you look at Judge Winnick's decision, page 8 of the hearing on November 8th of 2016, he says he's not precluding that. He says if it's outside of the testimony, he'll allow cross-examination on it, but he's not going to preclude it if we didn't get asked it at the deposition. And so it's exactly the opposite. Judge Winnick says, I'm not going to preclude the evidence if he wasn't asked at the deposition. Then we get to a different judge at the trial.
Right, the 2018 motion in limine, where you were warned, I think, that you would not be permitted to introduce it if it contradicted his prior testimony at the 30B6 deposition.
Again, Your Honor, and respectfully, and it did not. He was a 30B6 deponent, not asked. This was not a subpoena duces tecum deposition. He was asked to come in as the person with the most knowledge regarding this. Now, as often happens, Your Honor, he had no personal knowledge about a document in the file produced by an employee who had left.
But your client designated him, right, as the 30B6 deponent. Was there a schedule attached to the deposition subpoena?
There was a schedule of testimony topics, but nothing about documents. It was not a subpoena duces tecum.
So did he do an errata sheet after that?
I'm sorry?
Did he do an errata sheet after the deposition?
I don't believe he had any testimony to correct, Your Honor.
Was he the sole identified 30B6 deponent?
He was.
You offered, you have an obligation therefore, your client had an obligation therefore to educate him on all of the topics. He wasn't.
Correct.
He doesn't go to the deposition with just whatever his state of knowledge is ab initio. He needs to be educated to answer all of the topics on behalf of your client comprehensively. So I'm not really sure why it matters that it was about an employee, a former employee.
It matters, Your Honor, because he's not asked about whether there is a business record in the file, which if he had been, he would have said, this is in the file. I can testify that's a business record, but that employee has long since left, so I cannot answer anything about what actually happened with that receipt. All I can tell you is this is in the file. It has an account number on it. It's been produced in discovery.
He wasn't produced as a keeper of the records. He was produced in response to a 30B6 deposition notice. There's a difference. There's a difference between those two. What you're offering is only what a keeper of the records would testify to. And that's something different and less than what a 30B6 deponent is required to be able to speak to.
Yes, Your Honor, but that's exactly my point, which is he is the person with the most knowledge at the corporation as to certain things. He's never shown the document at issue. He's never asked, is this anything, do you know anything about this document, this receipt? Do you know anything about it? Counsel has it. We produce it in discovery. He's never asked anything about this relevant document. And so how can you then at trial say you can't testify? Judge Winnick said, if this witness gets up and you can show me, he was shown a document and said, I know nothing about it, and you try to put it into evidence, I will exclude it. He says, he doesn't say that there's
So let's say we accept your argument at this point. Where this takes us is, I think, back to pretty much Judge Blake's initial question is, who cares? Because that was not the basis upon which liability was found. So instead, liability was found on the basis of not keeping it in a separate account.
But, and what I would reply to that, Your Honor, is if that document had come into evidence with the account number and the name of the bank on it, the jury would have had evidence into which they could have found that it was properly put into that account. You don't have that.
Did anyone testify? We put the money in a separate account at
Citizens
such
Bank.
and such a bank?
No, Your Honor, because the judge excluded that receipt, which would have allowed them to do that.
No,
But they weren't able to do that.
Why couldn't anyone just say it? Someone, an employee of the company, just say, we put it in a bank account.
Your Honor, because I believe several times in the record, they tried to get into it and there was an objection that the witness was not allowed to go beyond his actual testimony. I would also say, Your Honor, it was an error to exclude the witness from Citizens Bank who was called, who was in the courtroom before closing started, and the judge stopped the evidence, even though it was a third-party witness under subpoena who had said they were on their way. The record shows they were actually in the courtroom before the closing started, and the judge excluded that person. And again, Your Honor, this is after the representation made by counsel, which I point to in the record, saying that the issue's irrelevant. It was irrelevant whether or not it was in the right account.
This is another area, though, that I'm confused, because when I look at the transcript and the things that Judge Theolopoulos said, she waited 3 hours for this witness. And this witness didn't show in 3 hours coming from Rhode Island.
Well, Your Honor, I would say she didn't wait 3 hours. They were in the middle of testimony. They ended, and she walked into the courtroom before closings or anything else. It's a third-party witness under subpoena, not within our control. As you can see from the record, we're calling and calling. There was no prejudice to then allowing her to simply, she was the keeper of records. She would have just handed the records in. We were alerting the court to the delay, but again,
so why
there was a few
weren't the
minutes delay.
certified records produced in discovery with the keeper of the records affidavit that you could have put in under Rule 34?
Because, Your Honor, if you look at the transcript of Judge Winnick's hearing, they had said they would object to that and they wanted a keeper on all these documents. And Judge Winnick says, you really want to take the court's time to do this for the trial? And they said, well, think about it. They wanted they insisted that the keeper be there to testify.
Did the trial judge make that ruling? I mean, why not have them in your back pocket so that if you can't produce the witness, you at least create a record where you offer the documents with a keeper of the records affidavit that they're true and accurate business records?
Because again, Your Honor, we were under the impression, if you look at the record, when raised by the judge, that the issue of it being in the proper account was irrelevant. It was not the issue. That's exactly what they said. Then we get told suddenly, no, now this is going to be the issue. We call the keeper of records to come in to produce the record there. Again, Your Honor, it's in the record what counsel says.
Judge Wolohojian, may I just ask one more question since the time has expired? Counsel, I couldn't find it in the record. Is there any objection to the special verdict form that was given to the jurors?
There was no objection to the special verdict form, Your Honor. But again, I do think it was error in that they got both an offset and they got warranty of habitability damages for that, and also that we did not get the $1,400 in the actual damages. So they got a double amount for double recovery for that, an offset on money they had not paid.
We're going to have to leave it there unless there are further questions. Let me see. No. All right, Attorney Siccardi and Attorney Turk, you should probably put yourself on mute given the issues we've been having with feedback.
Thank you, Your Honors. Good morning, and may it please the court. I'm Chris Siccardi, counsel for the appellees Kim Johnston and Sarah Strofsky. My brother has made a number of points that I would like to address in some detail because I do think some clarification of the record would be useful here. I would like to, if I may, just present a quick overview of our view of the issues that the appellant has raised.
Actually, I'm going to
Oh.
interrupt you to start.
Absolutely.
I have a couple of questions that are lingering for me.
Sure.
I understand your argument as to why the proffered document as to the security deposit receipt was excluded, but help me understand why it shouldn't be marked for identification for the appellate record. Things are excluded all the time, rightly or wrongly, but they're marked. So Attorney Turk is not in the position he's in, which is saying, I can't even show you what I would be arguing because she didn't let me mark it.
And Your Honor, I think that's a good point. And I think it probably should have been marked. But there's a couple of things I would say to that, because I don't believe that has any bearing on the case. I think it's a harmless error for a few reasons. First of all, as Mr. Turk mentioned, he wanted to get that in for the account number. What he didn't mention is that we stipulated to the account number already. So the very information that he wanted to try to get in through this receipt was already stipulated to, and that's at Record Appendix 5, page 8, lines 19 to 24. At trial,
you stipulated that it was a Citizens Bank account number XYZ.
we stipulated that it was deposited into that account number. So I think so for that issue, I don't think that they suffered any harm at all. And I think it's also
but for best practices and for a teachable moment, right? You mark everything.
Agreed, Your Honor.
Okay.
But I also think another important thing to mention here is that receipt was part of the lower court record. They did not produce it in discovery. And I would like to address what Mr. Turk said about that, because it's absolutely incorrect. But they did attach it to their opposition to our summary judgment motion on the security deposit receipt. And so they could have moved to include it in the record appendix. They chose not to. So I think that's worth noting.
So wait, tell me again, where would you say it was attached?
It's not in the record, the appellate record.
In the land court, I mean, the housing court.
In the housing court, Your Honor, it was attached as an exhibit to the summary judgment. Their opposition, we filed a motion for summary judgment on the security deposit issue. The motion was ultimately denied. In their opposition, for the very first time, we had never seen that. They never produced it in discovery, but at the first time in summary judgment, they did attach it. And while I'm mentioning that, Mr. Turk mentioned that we didn't ask about it at the deposition, and he's absolutely right, because they never produced it. So we couldn't have asked about it. Later on at summary judgment, they did attach it. And that's the first time that we had seen it. And
So
you'll know.
Are you arguing that the appellants could have included that in the record appendix on appeal?
I am, Your Honor.
By virtue of the fact that it had been an exhibit in the summary judgment papers?
That's correct, Your Honor.
Did you cooperate in the preparation of the record appendix, the parties?
We did not, Your Honor. We were not consulted in that, and that's why we filed a rather substantial supplemental appendix where we attached a lot of things that we think were very much relevant to the case, in which they excluded, like, for instance, the jury verdicts form, which I think is instrumental in showing what the jury actually decided with respect to the security deposit. And
can you address, and I'm sorry, it's probably out of order to what you planned. Could you
Absolutely.
address the duplicative damages issue?
I can, Your Honor. And I would say several things with respect to that. I don't believe that there are duplicative damages, and there are several reasons for that. There were warranty damages awarded, which are damages based on a physical defect in the unit. And then the judge made a separate finding that there was not that the landlord did not fulfill its duties under the contract. And under the verdict slip that, as Mr. Turk agrees they didn't object to, the jury was to first find if the landlord had complied with its obligations under the the contract, and because it found that it didn't, for any number of reasons. And I think that's the key here, is that while warranty of habitability damages go just to the physical defect in the apartment, the breach of contract and the failure to comply was related to many other things, like, for instance, the out of control parties in the apartment, the attack on Ms. Johnston by a neighbor, and the landlord's failure to address those things. And that's something that was both a subject of a lot of testimony at trial, and it was also something that counsel in closing emphasized as a basis for finding that the landlord did not comply. So I believe that those are two separate claims, and the facts and underlying them are separate, not duplicative, Your Honor.
Can I ask you about the exclusion of the neighbor's security deposit? As I understand it, the verified complaint, the purpose of that was to show what had happened between your clients and another tenant in the building, all under the watch of the holdings company. And I know I read that there was a suggestion, and I just can't remember, that the person that committed the attack was a relative of the landlord. Is that the same person, or is that a different person?
It's a different person, Your Honor.
Okay.
The person who attacked Ms. Johnston was a downstairs neighbor, unrelated. There was the daughter of the principal of Michelle Holdings lived in the penthouse above, and she was involved with the parties, but not involved with that particular attack, Your Honor.
And is it your view that by trying to offer the exhibits to the complaint, it was a backdoor around the ruling on the first issue?
That's exactly right. And I think Mr. Turk just clarified, made that crystal clear, that that was exactly what they were trying to do. And they were doing that because they didn't have any witness who could actually testify as to what happened. And I do think, that gets at something that my brother said a moment ago with respect to Mr. Karabulad's 30B6 deposition. He was the designee. And I think, the court has made it clear, that the obligation of a 30B6 designee is very different than the obligation of an individual deponent who may or may not know certain facts and has no obligation to research them necessarily. A designee could certainly go to his file and take a look at a document and then testify to it. And the problem—
And the 30B6 deposition subpoena did not include a schedule of documents?
It did, Your Honor. Actually, if you look at page 5 of the supplemental appendix, it includes a detailed schedule, item number 7 of which is the handling of any deposits Kim Johnston placed with you prior to or during her tenancy, counting regarding monies debited or credited to Kim Johnston's tenant account, communications with her. I think it's a little too clever for them to suggest,
Those are topics. Those are topics. They're not requests for documents.
You're right, Your Honor, and I apologize. You're right. There was not a request for documents. Our point is that there was a schedule of topics, and our expectation was that given that this designee was designated to testify to these topics, we would expect substantive response with respect to those. So our complaint is not—
Did you send a regular keeper of the record subpoena with documents to Michelle Holdings?
We didn't send a subpoena because they were a party in the suit, and we requested discovery. We requested all of these documents in discovery, and they didn't provide any of them.
Are your document requests in the record here?
I don't believe the document requests themselves are, but I can double check that because we did have a number of motions to compel.
On them, yeah.
And so, there's certainly discussion of them.
So the motion to compel starts at 158 of the supplemental appendix. But I see
It's a motion to compel deposition testimony.
right, not the documents.
That's right. I don't believe that those discovery requests themselves are part of the record. There is discussion of them in some of the motions that were filed, the various motions to compel, et cetera. But no, the requests themselves are not here.
Can I ask you about the court officer being positioned behind the gentleman as he was testifying? Did the judge give any instruction to the jury about that? And was that different than any other witness that had testified?
It was different, Your Honor. And the judge didn't give an instruction. What had happened is that Mr. Karabulad, he had repeated outbursts in the courtroom. And he was warned on a number of occasions about those outbursts. They happened on different days. And at the point that happened, the judge actually had to ask him to leave the courtroom. And his back and forth with the judge was because he was unhappy that he needed to come back for the 5th day of the trial. And he was hoping to finish on the 4th day. And he jumped up and expressed that in court in front of the judge. And she reprimanded him until finally she asked him to leave. And then when she came back, she did have an officer next to him. And I would note, Your Honor, that the landlord did not object to that at any point.
I also want to ask you, you ask at page 52 of your brief for appellate fees and costs. Are any of those statutory, or are you requesting them because you contend that the appeal is frivolous?
We, I do believe most of the arguments that they made, I think are, I would argue, clearly frivolous in light of the record and the contradictions to the record, a number of which the court has pointed out. And so to the extent that we are successful in the appeal, we're requesting those fees. Those statutes that we cite also authorize fees in a successful claim.
But are any of your claims, is it mandatory as a result of what the jury found and what we do on appeal?
Those statutes that we cite require attorney's fees where a tenant prevails. And those are, Chapter 93A, the Security Deposit Statute 1A615B, and breach of quiet enjoyment 1A614. I'm happy at this point, Your Honors, to rest on our brief. If there are any other questions dealing with anything, certainly I'm happy to address them.
Let me check. I don't see any. We have your brief. We have your arguments. Thank you both for your arguments. It's a very interesting case. We were helped by your arguments, and the case is.
We are going live and on the record.
Good morning, right under the wire. It's still good morning, and welcome to this sitting of the Massachusetts Appeals Court. With me today are Justices Blake and Kinder, and my name is Gabrielle Wolohojian. Although we are hearing this case in this format, all the ordinary rules of argument in our courtroom apply, including that each side is permitted only 15 minutes to argue and there is no rebuttal. With that, I'll call the case of Antonio Tesera versus Atlantic Charter Insurance, case number 2020P0353, and Attorney D'Ambrosio, we are ready whenever you are.
If it please this honorable court, Attorney Gregory D'Ambrosio representing the appellant. In this case, the employee sustained a workers' compensation back injury. The judge placed him on compensation, but stopped it retroactively based on one report, and only one report, the 2018 medical report of Dr. Nicoletta. And if I can start with some of the legal cases on issue number 2. And in issue number 2, we claim that there are 3 major legal flaws which disqualify this medical report. The first case is Roscoe's case. And Roscoe's case guides us that when there's no deposition, we have to look to the words, the four corners of the medical report, and we're limited by that.
May I interrupt you for a moment? I noted that you did not put into the record marked the copies of the exhibits as they were admitted in the hearing. How are we to know that the medical reports that are included in the record are the same? In other words, as long as, or what, that's the full document that was admitted at the trial or at the hearing.
Thank you for that question, Your Honor. And the judge admitted the documents, the insurance documents and the employees' documents in bulk. But I've examined all the records, and on the index that we've submitted, every single medical record that was admitted into evidence is there.
So are you saying that how are we to know that what in our record was admitted at trial?
Well, the judge, in his decision, itemizes all the documents that were admitted. And as I said,
so for example, let's say it's the report of Dr. Nicoletta. And I have a document called, the letter from Dr. Nicoletta in the record appendix, for sure. And it's 3 or 4 pages or whatever number of pages it is. But I don't know, for example, if at trial it had exhibits attached to it, medical records attached to it. I have no way of knowing that. I only have to guess, I think, as to how what's in the record corresponds to the actual exhibits at the trial.
I understand that, Your Honor. And unfortunately, the judge did not list each medical record with a specific number. He did them in bulk. There were no exhibits attached to the medical records of
So there's only one exhibit are you saying there was only one exhibit marked at trial?
No, I'm not saying that, Your Honor. On the decision, it lists the documents that are in evidence. And the judge, we put in like 10 different medical records, and the judge put, the employees' records of this exhibit, but he didn't specify and list each of the 10. Same thing with the insurer.
Okay, so I think the best solution here, so that there's no ambiguity, is that you cooperate and within a week send a copy of the actual exhibits at the hearing.
Well, I guess I'm confused. There's like 100 pages of medical records, and they're not broken down by the hearing judge. Exhibit 1, exhibit 2, exhibit. There is no.
They were introduced.
They were introduced in evidence.
Whatever was introduced in evidence, we would like to receive within a week.
Absolutely, I will send you.
As they were introduced. In other words, in total, in the order that, however they were packaged to give to him, that's how we'd like them.
If I may explain, of course, the hearing started in June. The record remained open for 4 months. The judge said you can submit them. So they were sent in by email at various times afterwards. And that's why we were not in front of the judge again, where he would say, this is admitted exhibit 3.
I understand. As long as the two of you cooperate and agree so that we know that we have exactly what that judge had, then that's all we're looking for here.
Thank you. If I may continue. So exhibit number, in issue number 2, we claim there are 3 legal flaws which disqualify Dr. Nicoletta's report, the report of 2018, which is in the index. That report is in the index that's before you. And at page 230 in the index. It's a 3-page report. And so Roscoe's case also guides us that there are 2 essential medical opinions that we need in these cases: causation and disability. So when we look at the four corners of this report, there's no opinion as to causation at all. And that's essential. So therefore, it's just a disability evaluation. It's irrelevant and it's worthless. So that's the first legal flaw. Secondly, King's case advises that when the medical report itself is inconsistent with itself, that creates a legal ambiguity which disqualifies the report. And the SJC in Anderson's case confirms that legally ambiguous reports cannot be adopted. Now, factually in this case, there was one MRI on page 2 of this report, which is 231 in the index. Dr. Nicoletta describes it as showing degenerative disc disease and bulging disc at L4-5 with mild compromise. But on page 3 or page 232 up top, he refers to it as a negative MRI. So now we have inconsistent and opposite references to the same test. So using King's guidance, this now is legally ambiguous and is disqualified. And the third flaw leads us to the standard of causation. And the insurer waived the affirmative defense of section 17A. So it has to be viewed in an as-is standard of causation. Dr. Nicoletta, in his diagnosis on page 231 in the index, says the diagnosis is lumbar strain in an individual with degenerative disc disease. Nowhere does he diagnose the bulging disc at L4-5. So he is not doing an as-is evaluation. He's eliminating that pre-existing condition. He's also not evaluating the degenerative disc disease, in my view, because he says in a person with it, meaning the person already had it.
What difference does any of this make if the ultimate conclusion of the doctor is that he is fully capable of returning to work?
Well, because the judge cherry-picked the disability opinion, and if it's disqualified legally, that opinion cannot be used in any way. And there are all these cases, Anderson's case, Roscoe's case, Fietta against the Boston Globe, that you have to use the right standard of causation. And the judge in his decision, and that's in the index at page 49, picks up Dr. Nicoletta's diagnosis of lumbar strain.
All right, so no one's, I don't think really there's any contest in this suit that there was an initial lumbar strain caused by work. No one's disputing that, and nor do I see Dr. Nicoletta disputing that. And so then the question becomes, how long, if at all, and to what extent did that affect his ability to work? If by the date of this report, the conclusion is he's fully capable of returning to work, then what do any of these arguments that you are making concerning Dr. Nicoletta's opinion matter?
Well, thank you, Your Honor. And I don't believe Dr. Nicoletta actually says that. He says in my objective orthopedic exam, meaning what he can see and what he can feel. And he clarifies that in his first report, his 2017 report, which is at page 222 in the index.
Maybe it will help you if I just read it. He says, based on my objective orthopedic examination performed today, along with review of all the documentation, including surveillance, Mr. Tesera is capable of working at full capacity with no restrictions. There is no permanent impairment.
Yes, and objective, he clarifies that in his 2017 report, what he means by objective is a very important qualifier that there's no objective evidence of impairment from what he can see. And when he says that, he cannot.
He also includes all the documentation.
He does, but he's only evaluating the lumbar strain and he's eliminating the two pre-existing conditions, which he cannot do, of the bulging disc and the degenerative disc disease.
He doesn't say that, but even if we were to agree that that were the case, as I said, what difference does it make if he's fully capable of returning to work?
Well, because the doctor is using the wrong evaluation, the wrong standard of causation. The judge picks that up standard in his decision at page 49, where he diagnoses lumbar strain, even though the judge says it's a work injury that's compensable. But the judge does not consider anywhere in his decision the bulging disc or the degenerative disc disease. So
the judge acknowledged that there was degenerative disc disease.
Yes, and the report is deceptively written because he does not diagnose, the doctor does not diagnose bulging disc anywhere, only lumbar strain. And so he's saying there's no radiculopathy and no radiating symptoms from the lumbar strain, which we agree. He says there's no radiculopathy. There is none because the EMG would have to be positive. The impartial testified that a negative EMG does not rule out back pain. That's at 325. And that the degenerative disc disease and the bulging disc can be disabling. That's at 271 and 272 in the index. So, you know, Dr. Nicoletta's report is flawed, it's deceptive, it's convoluted, it's inconsistent, it's legally ambiguous, it has the wrong standard of causation, it has no opinion as to causation, and the judge picks that up, and that's the legal flaw on issue number 2.
Are you contending that there was any cause for the employee's injury other than the work injury?
No, the work injury, when you take the employee as is, Orlovsky's case, pre-existing conditions, personal injuries within the act, you have to take the employee as is. So he had a lumbar strain, but he already had degenerative disc disease. He already had a bulging disc at L4-5. You have to evaluate all 3 conditions. That's the test Dr. Nicoletta should have done, but he didn't do it.
Well,
he did the wrong one.
Dr. Nicoletta is not at this point, I don't think, determining causation. He's determining his capacity to return to work.
Yes. And he has to evaluate all 3 conditions, but he doesn't.
But he makes an overall conclusion that he's fully capable of returning to work.
It's a flawed hyperbole conclusion because he says there's no radiculopathy. The neurologist says there's radiculitis, a similar condition. The suffix itis stands for inflammation. And so he says a negative EMG, but the impartial says a negative EMG does not rule out back pain. That's at 325 in the index. And the impartial also.
Was the judge free to adopt parts of the doctor's opinion and not others?
Yes, Your Honor, you could adopt part, but still it had to be a legally safe decision. If it's legally flawed and there's 3 legal flaws.
What do you mean by legally safe? What does that term mean?
In other words, there's an absence of a legal flaw. There's 3 major legal flaws in Dr. Nicoletta's decision. There's no opinion as to causation. It's inconsistent and legally ambiguous, King's case. And it's the wrong standard of causation. He did the wrong disability evaluation. And therefore, you know, it's like if the doctor said, you know, I just.
Your argument, I get the sense that your argument really is that you just disagree with the weight that the judge gave to the evidence. And that's certainly within the fact finder's purview.
No, I'm not disagreeing with the weight. The judge can judge the weight, but it cannot be legally flawed. I mean, it's just like if the doctor said, you know, I flipped a coin, heads he's disabled, tails he's not disabled. It came up tails, he's not disabled, or it came up heads. You know, that's a flawed report. The judge cannot adopt that. That's what those cases, King, Roscoe, Anderson, and Theater against the Boston Globe guide us. Okay. If I can switch to issue number 4, the judge in this case did something that no judge should ever do. He became a witness in the case. And he picks it up in his decision that the employee is not in pain and no restrictions. And the apostle testified that no doctor in medicine can see pain. That's at page 272 and 273. So this judge is trying to do something that no doctor can do and that I can see is not in pain.
Okay, we're going to have to leave it there because your time has expired. Let me just check to see if there are any other Questions? No. All right, thank you. Attorney DeGaravilla.
Good afternoon, and thank you. Anna DeGaravilla for Atlantic Charter Insurance Company. In this case, which I would argue was not an extraordinary case and did not have unusual facts, the administrative judge found that the employee was evasive during his testimony. He found that he purposely attempted to understate his past work experience and his ability to speak and understand English. That's a credibility finding made by the administrative judge that should stand. It should not be set aside. That is something within the purview of this administrative judge. Further, he admitted medical evidence and then made a determination as to what weight to give the medical evidence that was properly admitted. My brother addresses the report from Dr. Nicoletta and argues that somehow it's flawed because Dr. Nicoletta doesn't give an opinion as to causation. There is no requirement as to what an individual medical record has to accomplish. Maybe he's referring to Section 11A, the impartial physician, in order for his report to be adequate, must meet certain standards, and one of them is to give an opinion as to causation. In this case, the administrative judge, in fact, relied on the treating doctor's report, a report from Dr. Kennard, to determine that there was causal relationship between the industrial incident and the lumbar strain, something that we had not contested. Once liability was established for that industrial injury, the judge was free to review the medical evidence, weigh it, and determine which opinion he was going to rely upon to determine the extent of disability, if any. And that's what he did in adopting the report of Dr. Nicoletta from September 29 of 2018.
Counsel, it wasn't crystal clear to me from the briefs what standard of review you were suggesting we should adopt in reviewing the ALJ's decision here.
Well, I had argued prior to the hearing that the judge should apply the Section 17A standard, the heightened standard of causation, on the basis of the pre-existing underlying condition of degenerative joint disease in the lumbar spine. And the judge denied my motion, which means at hearing, the issue was, is the industrial accident the cause of the disability and the need for treatment? There was no heightened standard. The judge applied the standard that my brother is suggesting he didn't apply, or saying that he should have applied. He in fact applied the appropriate standard of causation.
I hear you with respect to the standard that the ALJ applied. What is the standard we apply on appellate review?
As to the issue of causation?
As to the decision, the ALJ's decision.
Well, I think the administrative judge's decision needs to stand unless it can be established that it was made beyond something beyond its scope, that it was arbitrary and or capricious, or that it was contrary to law. And I would suggest that none of those things are here. This administrative judge was well within his authority to make a credibility determination as to the employee's testimony. He was well within his authority to weigh the medical evidence and adopt parts.
So are we doing a 30A review?
Yes, I believe so.
We're technically reviewing the decision of the board, the reviewing.
Of the reviewing board, and the reviewing board summarily affirmed the decision, which leaves us with the hearing decision. And the fact of the matter is the hearing decision is supported by the evidence and was well within the administrative judge's authority.
You know, I'll just say, speaking for myself, that I'm always disturbed by these awards that result in the employee having to pay back an arrearage where the arrearage was caused simply by compliance with a previous, payment schedule set by a judge.
And I certainly understand that concern, Your Honor. And that's a function sometimes of delays the function of waiting for hearings to come up and from a conference order and then waiting for a decision. In this case, the administrative judge could have relied on an earlier report from Dr. Nicoletta in December 2017. He could have relied upon the report of the impartial physician in April of 2018, but he chose to rely on the opinion of Dr. Nicoletta in September of 2018.
Even so, it resulted in a large arrearage.
It does, Your Honor.
That doesn't trouble you?
Well, unfortunately, I don't see any recourse to it. The administrative judge, certainly in the past, there have been decisions where administrative judges finding that there was no ongoing disability terminated the disability as of the date of a hearing decision. And those decisions were overturned because the date of the end of the disability was not rooted in evidence. So the decision of the administrative judge has to be based on the evidence that is offered to him, that is before him. I don't see that he would have, to have done so later would have caused error.
There's no remedy for, let's say, excusing or relieving the employee of a repayment where the excess payment was made simply by the insurer complying with the court's, schedule of payments?
I will say this, Your Honor, in my experience, and I've been doing this a very, very long time at the Department of Industrial Accidents, in cases where there is an overpayment, an insurance company will often seek reimbursement. They will go to the Department of Industrial Accidents and seek an order of reimbursement. And very rarely is that paid, simply because there are no assets with which to seek repayment. I mean, in all of my experience, and I've been doing this since the late 80s, I've never seen a situation where payment was made back to the insurance carrier because of an overpayment such as created in this decision.
But is there are collateral consequences from an order such as this for the employee?
As to finances?
They have this judgment.
Well, it's a determination of the Department of Industrial Accidents. I don't believe there are any collateral consequences, Your Honor.
I put a lien on property if he owned property?
I don't believe they could do so from an order at the Department of Industrial Accidents. Could they pursue that further? Perhaps. I've never seen it done, Your Honor. And again, the issue is a termination of the benefits at a later date, not rooted in the evidence before him, would have been objectionable, and those cases have been overturned.
No, I'm not saying the solution is just to make up a later date of, I'm not saying that. I'm just trying to work out, is there a solution? Because, this doesn't sit easy, at least with me, to see such a, for a person who doesn't make a lot of money to begin with,
right?
There's no suggestion that the person, did anything to fraudulently obtain benefits, that he wasn't injured, that et cetera, et cetera, et cetera. The function of the existence of the excess payment is purely a function of an original award of how much should be paid by the administrative judge. And so it bothers me to have the employee have such a large liability back to the insurance company in those circumstances.
I can certainly understand your concern. And at this point, in my experience, I don't see a remedy for that. That's something that perhaps is something should be addressed by the legislature. I do not know of a remedy for this particular problem. And at this point,
you're telling me that de facto, they're just telling me de facto, the solution is that the insurers do not seek to collect that.
That is my experience, Your Honor. And my experience includes working as a defense counsel for insurance companies and also doing plaintiff's work. It's, the expression, you don't get blood from a stone. it does not change the fact that there is an overpayment. And that is unfortunate, but it does not change the underlying facts of the case and the finding of the administrative judge that the employee was capable of returning to work and no longer eligible to receive weekly indemnity benefits.
All right, thank you for clarifying that for me.
Yeah, but I certainly do appreciate the concern. This is a case, in my opinion, where Employees Council was simply unhappy with the decision of the administrative judge that was fully within his authority and his purview. And we would respectfully request that the summary affirmation of the reviewing board be affirmed as well. And unless there are further questions, I'll rest on the briefs. I'll also certainly cooperate with my brother in putting together the package that you've requested for next week.
Yes, I appreciate that.
Yes.
And if the two of you can do that, it would be very helpful. We just want to have exactly what the judge had.
Yeah, absolutely.
With that, thank you both for your arguments. It was very helpful to